and that hurt. So
Yes.
this didn't hurt going in at least, but yeah, no, my arm was
Later on,
sore.
yeah.
Well, I had a little golf ball in my arm for about a week. It was like, it wasn't funny, but I think the second day or the second dose, actually, if you have reactions, it's because you already have some of the antibodies. And so it's starting to fight that. And I felt pretty sluggish the next day.
Yeah.
And a little headache, but that was it, thank God.
Yeah, I was told that if you had a reaction, it was good. It means everything was working correctly.
All right, well, it's 2:36, so why don't we go ahead and get started? I'm so glad to see everybody. Happy spring to everyone. Before we get started, I'd like to introduce or just glance over the board of directors for CRE Silicon Valley. Oh. Oops. There's our 2021 board of directors. So the schedule for today, from now until 11:45, we're going to go over a few announcements, and we're going to do some networking at 11:45, and then noon, we're going to jump into our panel discussion. First, we want to always thank our sponsors. They're so important to our events and CRE Silicon Valley. So our platinum sponsors are One Workplace, Washington Holdings, HGA, Impact Group, BBSI. Stuck again. And our gold sponsors are Perfection Services, A Vision Young, American Asphalt, Arborwell, Paul and McKay, Iron Construction, and HMH. And our media sponsors are Silicon Valley Business Journal and the Registry. So this is my favorite part of the event is we're going to welcome our new members. I have to admit, that again, this is my favorite part of the event. We're able to recognize our new members and invite those who are guests that are interested in CRE Silicon Valley to get information regarding membership. So if someone from the board could put in Lee's contact information into the chat, that would be great for those who are interested in membership. So Carrie is a senior leasing manager with Prologis. She's located in Fremont. She is a transplant from the East Coast and moved to the Bay Area in 2017 from Alexandria, Virginia. She's in a commercial real estate business for 7 years. And she also has a twin sister who is also in commercial real estate. Next, we have Mary Jane. She's the Marketing and Business Development Director for Iron Construction. She's trilingual, fluent in English, Spanish, and American Sign Language. And she loves socializing with both humans and dogs. Next, we have Reggie Fuchs, Senior Project Manager for Center Build. He's a husband of one and a father of 4, and he enjoys fishing, barbecuing in the backyard between engagements. And lastly, we have Connie. She's assistant to the city manager, economic development with the city of Sunnyvale. So our upcoming events, we have April 21st, the Rising Leaders will host an event on April 21st, 4:30 to 6 p.m. Please check it out. And our monthly happy hours on May 20th and June 24th, we are hoping to have an in-person event. So now, Anna, would you unmute yourself and give us some information on Elevate, please?
Hi, everybody. We are going to be celebrating the 5th annual Elevate Awards ceremony via Hop-In this year, May 6th. It is awards celebrating diversity and women's leadership in commercial real estate. We will be honoring employers who have implemented programs promoting greater diversity in the workplace and also shine a special light on exemplary women, men, mentors, and standout crew members who are making a positive impact in today's real estate industry. This year, we had over 500 nominees and 200. So you get a bunch of duplicates, triplicates, which is amazing. So 240 nominees that participated. The theme this year is resilience. And as you can see who our special guests are, looking really forward to that. A part of the registration, you will be getting Dion Lim's book. We encourage everybody to sign up as soon as possible. It's going to be just an amazing event. I can't wait to, where we can announce all of our winners and runner-ups, and the program, it will be one of a kind. So please, everybody, sign up as soon as possible.
Thank you, Anna. Nathan?
Awesome. I wanted to just build on the awards momentum and make one quick announcement. Michelle, can I share really quick my screen?
You can. Sure.
Thank you. Okay, so everybody knows about tax day, or rather the old tax day, April 15th. Well, that is no longer tax day, but it is still the deadline for the CRE Network Impact Awards. And we would really love to have some awesome Bay Area awardees this year. So CRE Network does a national awards program with 5 really awesome awards categories. And they announce the winners at convention. And so if you go on to CRE Network and go to About and Awards, it'll take you to the Impact Awards page. It's super easy to nominate. And these awards categories, I'll bet you, if you just flip through your Rolodex, you'll think of some awesome recipients this afternoon, maybe when we're done with our program. But these are awards for crew members. So take a look at the categories. It's super easy to submit. You don't have to do all of them. And let us know if you have any questions. Thank you so much, Michelle.
Thanks, Nathan. All right. So we are done with our housekeeping. So we're going to move forward with our program. And I'm going to introduce Jill.
Michelle.
Before, actually.
Sorry.
Yes.
Did we, are we doing breakout at the end or at the front?
You know, we are going to do it now. I was just going to switch to I apologize.
Sorry. I was looking forward to that breakout room.
We're going to go into the breakout room. And our question is, what is your favorite way to stay connected with clients? Social media, email, text, calls, old-fashioned snail mails. So let's please remember, give everyone a chance to join in on the breakouts, and we will see you in a few minutes.
All
Thanks,
right.
Nathan.
Here we go. No, thank you. So I'm making these rooms up. They're going to be randomly assigned, and we're going to do, how many rooms should we do? Let's do 6 rooms, and we're going to open them all up. Remember, give your co-roommates ample time to chat and go forth. There we go. Nancy's joining here. Sorry, Michelle, I didn't mean to interrupt you like that.
No,
No,
thank you. Thank you, because I actually should have changed the slides.
Yeah, I figured it was just you had the slide at the end of the slideshow.
Yes.
But you were in the zone. You were in your housekeeping zone.
Yeah, sorry.
That's okay. Hey, Nancy, how are you?
I'm unmuted. Hello. Hi, Nathan.
Great to see you. Thanks for jumping on. So we just sent off our attendees into breakout rooms for their networking discussion.
Okay.
And you're welcome to join one of the rooms if you like, or you can hang out with us.
I mostly thought I wanted you to know that I'm here so you wouldn't be nervous.
Yay! Nancy knows how we are. That's great. And Michelle, you looked and sounded fabulous. So the tech issues obviously resolved themselves.
Good, thank you. It's so weird when I'm not in my office. So, you know, I'm just kind of out of sorts. You know, I'm unlike the millennials like you. So I can't move around like you guys.
Yeah, right. Yes, you can.
Nancy,
It
great.
looks.
How's the weather? Are you in the city? Nancy?
Oh, I wasn't sure if that was a question for me. It's a little overcast.
Yeah, are you in the city?
I am in the city.
Oh, really? Okay.
I suspect you guys are wearing sunglasses and I'm wearing my parka. Some truth?
Yeah, I think so. I think it's you know, I'm actually in Atlanta, and the weather's pretty nice here.
Amazing. Technology.
Yeah.
Are you in Atlanta indefinitely?
No, just here for a week or so. My daughter's having her second baby, so I'm here for that. Yeah.
How exciting.
Yeah, really exciting.
Yep.
Yeah.
How old is your other grandchild?
She is 18 months. So she's going to have a little sister any day now.
Well, we've done that. We have 2 grandchildren and it's so much fun. And the interaction between the two is so much fun.
Yeah, I definitely enjoy it. I tell you. Before you jumped on, I had my slides rearranged, the last slide incorrectly. So I was already going to start the program without doing our breakout room.
Start at the end.
Yeah.
That's okay. My mom, who grew up in Atlanta, she was a journalist. And I'm trying to remember what her sort of writing advice was. And it was something along the lines of, don't wait, don't try and come up with the perfect first sentence, just start in the middle. And then you'll figure out what it was that you were, your theme was. Just jump into the middle.
I love it.
Yeah. So are you muted, Michelle?
I was muted. Did you hear me?
Now I do.
Okay. Yeah, I was, so I'm actually working on a Mac computer, and I don't typically work on a Mac computer, so it's a little different for me.
Yeah. Well, I was going to, try and control my environment. So I thought I'm going to shut the door to the home office, otherwise known as the second bedroom. And so that way, if the dog starts barking, we have a little piece. And then I looked down, it's like, nope, he's on the floor right in here. So I thought, better not close the door.
It's so funny that, COVID, we've like kind of invaded our personal space, right? So we've come
Oh,
into
so true.
everyone's homes. And then, the great thing about it is that when you're having meetings, like if the dogs bark or you hear children, it's like, that's what happens because you're at home, right?
It's real life.
Yeah. Yeah.
Yeah, back in the day when one had to pretend that one didn't really have another life. It was just kids, doctor's appointments, Peachtree, whatever.
Yeah. Yeah. I think since COVID, I've had 3 doctor's appointments virtually.
Uh-huh.
So yeah, it's interesting, having a doctor's appointment virtually.
You don't get to, well, maybe you do get to sit in the waiting room. I guess I've had one virtual one. And
Yeah.
it's a little bit waiting, but boy, the convenience. It's not,
Right.
I couldn't complain.
Yeah. We've been looking forward to this event. This is going to be a good one. I know we'll have lots of audience participation.
Well, and I'm wondering, I've always thought Silicon Valley that crew must be much more spread out. And I wonder if Zoom makes it a little bit easier for everyone to assemble.
Yeah, we have had higher attendance and cross chapters, so it's been really nice.
Yeah, yeah.
Yeah, but I don't think anything beats meeting in person and being able to hug and say hello and
Yep.
yeah. So
Well,
that's quite. I miss that a lot, actually.
soon, as that vaccine spreads, pretty soon, everyone's hugging again.
Yeah. I had the J&J a few weeks ago and I haven't had any issues. I think I'm right at 2 weeks now.
Oh, that's fantastic.
So
That's
yeah.
fantastic.
Yeah.
Because I think when you go, you don't know what you're going to get. I thought I'll take any of them.
Yeah, I actually signed up. I wanted the J&J because I just wanted the 1 dose. So I was very happy. I got an email from a friend of mine who they were hosting the J&J rollout. So I was able to get scheduled for that.
That's pretty nice. I was one of those people that was a wait list. I drove to Santa Rosa from San Francisco, not knowing for sure if they'd have any extra. I was lucky I did, but
Oh, nice.
I got to the point where I was.
So did you?
Yeah.
You got the 2 dose?
I got a 2-dose Pfizer. Yep.
So then you had to go back to Santa Rosa for the second one?
I did. It was interesting. My husband went the first day, put me on the wait list. I drove up that afternoon, and then we both were able to go up for the identical appointment for a second dose. For something that important, it's okay.
Nice.
And it was a pretty drive.
Yeah. It looks like they'll be coming out of the breakout rooms momentarily.
Great.
Hi, everyone. I just joined a little behind.
Hi, Betsy.
Hello.
They're just in the
Hello.
breakout room.
Real quick. So I enjoy phone calls just to contribute to the conversation.
Nice.
I miss having that interaction.
Yeah, me as well.
Yeah, I know what you mean. It's sometimes just getting stuff done. Email's very efficient, but the connection between a phone call is so much better.
Right. Hey, Sarah. Oh, shoot.
connect to the client, social media, email, text, calls, fashion, snail mail.
Betsy, what firm are you with?
I'm sorry?
What firm are you with?
I'm with Restoration Management Company.
Oh, nice. Okay. Great.
Yes.
Hey, Michelle, did you say something to me? Sorry, my audio is messed up.
No, I was just saying hello.
Hi,
How are you?
I'm great. Sorry I'm late, trying to do 2 calls at the same time. You know how that
Oh,
works
yeah,
out.
that's always challenging.
Yeah.
No worries. The breakout room should be ending shortly. I think they're ending now.
Okay.
Yeah.
Hi, Nancy Lundeen.
Hello. Who said that?
Nancy Morse.
Hello, Nancy Morse. I wondered if you'd be on.
Everybody back yet?
Are we still breaking out?
Well, if you're a
Yeah, they
teenager,
should be
yes.
coming back.
I think we've broken out, Brian.
We've broken free.
Hello, Miss Nancy Lundeen, Tilly Ross here. Good to see you.
Hello, Tilly. Great to see
Oh,
you.
hi, Tilly.
Hey, how's everybody doing?
Good.
Great.
I noticed we have a special guest in the audience. We have Dale Green joining us today. Hi, Dale.
Hi, Dale.
Dale, 1, 2, 3. Hello,
Hi,
Dale.
Hi, Dale.
Hi,
The retired
everybody. I
person
miss
you.
you all.
Dale, do you want to give us a little, update on what's happening?
And who are
Oh,
you with?
sure. Let's see. I've spent the last year in my pajamas with no makeup. And as all of you know, lipstick is my favorite tool, but I've had to cover my mouth. I'm going to burn all of my pajamas. But no, it's been a wonderful year. We're fully vaccinated. We love where we live. It's very peaceful. And of course, I would love for any and all of you to come up and visit whenever you'd like. It's a gorgeous lake. So truly, being stuck at home most of the year, we really did keep isolated. We did a lot of projects on our new home. And I don't know if you guys know, but I went to Guatemala in 1918 or 2018. I really don't even know what year it is now. I'm very old. I'm petrified. And anyway, I met this wonderful lady that is sitting next to me in Guatemala.
Oh.
And interestingly enough, we came back from Guatemala and found out that we were neighbors practically in Los Gatos.
Eh,
And then when we moved up here, she had a home where we live now. It's just crazy. So we apparently we were meant to be friends for
so
sure.
you didn't smuggle her into the country.
No, I made her
Okay.
walk.
Yes.
Anyway, so really nothing
Welcome.
new.
Thank you.
So everything's good.
Great.
All right. Well, I'm glad you guys enjoyed the breakout room, and I apologize for the mix-up. I didn't want to miss our networking. So now we're going to move into our program, COVID, Commercial Real Estate, and Legal. Thank you all who submitted the questions via the registration portal. As the program committee worked to develop this subject matter for discussion, we needed a strong moderator, and the first name that came up was our very own Jill Collins, an active member and past president of CRE. Jill Collins is the Director of Operations of Real Estate Management Services at Colliers International. Jill is currently overseeing 3.5 million square feet of assets, which consist of residential, retail, office, industrial properties from Hayward to Watsonville. Jill is also an active member of CRE. Jill, the floor is yours.
Thank you. Hi, everyone. Thank you for joining us. We're really excited to have you here. As someone in the property management side, this topic is near and dear to my heart because I've been living it for a year and we're not done yet. So we've got a lot more to come. You have a great panel for you. We have Ginger, Sarah Ann, and Nancy. Ginger is a partner with Paul. Her area of expertise is commercial litigation and business litigation, focusing on real estate and financial institutional matters. Ginger is president of CRE Silicon Valley, and I was lucky enough to be on her board when she was president. I'm sure you're going to love to hear what she has to say. Another panelist we have is Sarah Ann Shapiro. She is special counsel with Paul McCain, enjoys her practice in the area of commercial real estate, business law, and employment. And she also teaches at college. I know because I've been a guest speaker at her thing. Her students love her. She's a great teacher. And I'm sure she's got a lot of fun things to share with us about the policies and the public-private stuff going on out there. So wait, tune for that. And our other panelist is Nancy Lundeen. She is a partner with Allen Matkins in San Francisco. She's skilled in a full range of real estate transactions, including the purchase and sale of real estate finance, commercial leasing, including office, retail, and industrial, and loan workouts. And Nancy's going to give us her top tips about some things later. So start this program with, I asked each one of the panelists to share with you their oh dang moment, because these are people who were definitely forward thinking the minute the pandemic started and probably had a lot of thoughts and ideas, but I wanted them to share with you maybe one thing that they didn't see. We're going to keep this part a little bit brief, but one thing they didn't see coming and what caught them maybe a little bit by surprise. So if we'll start with Ginger.
The biggest surprise for me was how quickly government agencies could act to basically throw lease terms out the window.
Okay. Nancy?
Sort of my oh dang moment was within a couple of weeks after we started sheltering in place, I closed a loan and had to get the original promissory note overnighted to my client. And so, okay, go down to the FedEx office. An hour later, I emerged and thought, this is not quite as easy as it used to be, where you hand it to your secretary and go on with your day. And in fact, I'll have one of the tips I'm going to give you relates to that experience.
All right. And Sarah Ann?
I will be the first to admit that I never would have ever predicted or imagined we'd still be doing this a year later. You know, when I packed up my office to bring it all home, and I'm thinking, okay, we're going to do this for 3 months. I'm thinking, okay, it's gonna be March, April, May, by June, we'll be back. And then it was July, and then it was August. And then I'm thinking, oh my gosh, how long will this go? Okay, it'll only go to the end of the summer. I can do this. If I had known then what I know now, darn it, I'd have brought my office chair home.
I did. That was the one thing I had to go back and do.
And get your office chair. Did any of us imagine we would still be doing this a year later, that this was not a 3-month thing? I still can't believe it.
Well, thank you for sharing that. And by the way, we are going to have a 10-minute Q&A at the end. So if you have any questions for the panelists after they get going, please put them in the chat room. Michelle's going to assist me with pulling out some questions at the end. So that's a great opportunity for you to put it in there, or any comments, please put them in the chat room. We look forward to having that time with you at the end of this. I want Sarah Ann to briefly share with you how are today with respect to the government regulations that disrupted the normal landlord-tenant relationship, which Ginger alluded to right away. They couldn't move quick when they wanted to. So take a couple of minutes, Sarah, and just kind of recap what that happened and how that disruption happened.
Sure. So as we know, one of the big things on the top ended up being a fear that people were going to get evicted. And I believe that as an industry, we were caught a little flat-footed. We certainly expected there was going to be action on the housing side, on the residential side, but that's also a highly regulated area and a highly regulated industry. So they started out with, people who were in rent-controlled apartments and affordable housing. I think it caught us all by surprise when the 2 things happened. First, the governor put out an order saying that counties and cities had the right to suspend the right to evict tenants for failure to pay rent, and the courts closed. They simply closed down any right to evict for any reason, and that went on all the way until the end of August. So we found ourselves going from March to August with the court simply closed. It didn't matter if the tenant was burning down your building. It didn't matter if they were or weren't paying the rent. It didn't matter that their lease expired. We were just shut down. Then they passed, and then the governor was extending the order. And the original reason for that, the rationale that the governor's office gave, was they wanted to simply hold everyone in place while the legislature had a chance to act. Well, the legislative cycle ends August 31st. That's why the order and the court closure was to August 31st, so legislature would have time. And as we know, they did try, SB 939 was last year's effort to control our industry and give tenants the right to terminate their leases. I had the opportunity to serve as lead counsel on the opposition to that, and we were very pleased to be able to defeat it. So when SB 939 failed and we thought the courts are reopening, then we thought, okay, we can get on with our regular contractual relationships. Unfortunately, the governor continued to extend the order. And as a result of that, it put everyone in a very awkward spot with landlords not knowing what can I do, what can't I do, what's allowed, what isn't allowed. Cities have their own statutes, counties did their own statutes. And unfortunately, it's resulted in a situation where we have any number of tenants who haven't paid the rent for a year, whose leases are still in place. We can't get rid of them. We can't get new tenants in that will pay. And in some cases, the tenants are perfectly capable of paying. And if you actually push on them or you file a suit against them, they do pay, but they don't feel the need to have to. Now, of course, in any situation, you have good people and bad people. And there are tenants who, despite the fact they don't have to pay, are paying their rent. They don't want to build up a big amount. And, God forbid they embrace their contractual obligations, and I salute them for it. But we're now in a situation that has stretched us from last March all the way to now, potentially further, with tenants who can pay not paying, tenants who can't pay struggling, and with the removal of late fees and interest charges, there's no incentive to pay. So here we are.
To where Ginger is, because she's the one who's got that lease, tried to have the conversation. Thank you for the great explanation, Sarah, on where we're at today and how we got there. Ginger, why don't you share with us some of the stuff that's, the real challenges you've been finding with the leases, and obviously your advice to your clients and what's been kind of going on in this last year from, we have these existing leases. What can we do with them?
Well, the big question with the leases that we have is, did the lease have a force majeure clause in it? Force majeure in French means superior force. And the force majeure clause talks about what will happen when an action occurs that we cannot control. And most of the leases that we've had to deal with have those terms. And those terms say that most often the tenant must continue to pay rents during these times. Some leases didn't have any kind of term that affected force majeure, and some leases allowed the tenant to defer their rental payments. So for those leases, we've had to figure out what to do, and we'd have to fight with the tenant about continuing rental obligations. For the leases that we had that provided the tenant, the landlord with the opportunity to continue to pay, landlords have been trying to get additional rent, CAM payments, base rent payments, anything they can. Unfortunately, even though we had these great leases that were drafted well to give us all of the protections that we needed to collect rents during this time, as Sarah Ann discussed, the government put in all these restrictions on what we could do. So now rent payments don't have to be made. Rent payments can be deferred. We can't collect interest. We can't collect late fees. And we're stuck trying to figure out what to do, how to pay lenders, how to pay for the continuing operations that we have to pay for at the properties, with putting everybody in a huge financial strain. So with all my clients, we're trying to be creative, trying to figure out Can we negotiate something now? Do we have to wait till these eviction moratoriums are over and then there's going to be a mass run to the courts to evict everyone? Can we afford to evict everyone and have completely empty retail centers and offices? What is the best way that we can proceed? As Sarah Ann expressed, her and I are putting a lot of our tenants into default now. And when they don't respond to either negotiate or to pay, we're filing collection actions because the eviction moratorium doesn't prohibit that. And we're taking them to court. We're making them spend some attorney fees and know that this is very serious and we need money to operate. It has been effective for me, and I think Sarah Ann too, but for those tenants that can pay but just are not willing to pay. What I'm doing now with regards to the leases that we're dealing with is really revisiting the leases to see what we can do in the future to prevent this from happening again. I don't know we can do very much with the government interfering as much as they are, but what kind of security do we have? Can we get more security later? Can we get a better security deposit to help us pay for this period? Can we continue to go to court and spend all this money to try to get the tenants to pay? And what other things can we do to get the tenant to understand we're all suffering some harm here?
Definitely. Either Nancy, do you have like any of your existing leases in addition to what Ginger said, some other, items that you've been dealing with your clients and how you've approached it?
Yeah, actually, I have several suggestions on kind of from the lessons learned, what we're often at my firm doing with our leases. And more of this is going to sound like it's from the landlord standpoint, sort of true, but not completely, because there's always both sides of the coin. And if it's an issue for one side, it's probably an issue for the other. And if you could just be alert to it, you can then try to address it and not be blindsided one way or the other. So my first suggestion that I'm able to do, not all the time, because sometimes it just plain doesn't work, but that is to include a provision in a promise, in a purchase agreement, a lease amendment that allows the document to be signed electronically. And I deliberately exclude that provision that says, oh, and by the way, you still have to go, in my words, stand in line at FedEx or the post office in order to make this electronic signature work. I tell my client, really, are you really going to make the other side and you're going to do that? Let's just get rid of that. Let's just have a really strong provision that electronic signature will work. And so I've, got a provision I feel very comfortable with. It won't work for a promissory note. I don't know a lender that will accept it or for guarantee. So anything that needs to be recorded, obviously, that's not going to work, but many times it will. Something to keep in mind as I'm sort of going to go through a handful of these lessons learned is that landlords are typically also borrowers. And I have, over the last year, seen some concessions given by landlords, many fewer concessions given by lenders. And if the borrower doesn't get the revenue in the door, it can have a consequence such as a cash trap event happening where now all their money has to go through the lender to ultimately default under a lease. If they don't have the money or they haven't met debt service coverage ratio or something like that. So it can be pretty serious. Sometimes the landlords, they're not just being stubborn. This is their lifeblood. And if they don't get the rent, the revenue, they risk, again, potentially losing their building. So I agree, Ginger was talking about force majeure, and that is one of the first places that we will kind of tinker up our lease. We're now revising it to expressly include epidemics, pandemics, quarantine, shelter-in-place orders, stay-at-home orders, travel restrictions, similar governmental orders, all of which can affect the ability of one or the other party to perform its obligations. And we will expressly exclude the ability to pay rent, that is not a force majeure. Force majeure does not allow the tenant to not pay rent. But consider force majeure should it indefinitely extend, for example, commencement date. Should it indefinitely extend the deadline for a landlord build out before a tenant might start getting rent credit or an ability to terminate a lease? So kind of thinking about how force majeure works, and should there be some exclusions? Kind of, you know, if you have that in mind, you can kind of think through what makes sense in your particular deal. A handful of revisions that we're making to the lease in sort of trying to address what I'll say are some of the creative arguments that tenants and tenant lawyers have made to try and either avoid paying rent or ultimately to try and terminate a lease as a result of the pandemic and kind of the related situation. So one thing that we're looking at is the interruption of services. And what we're now trying to do is limit the ability to get rent abatement if there's interruption of services to where it's a matter that was within the landlord's control, which would not be a pandemic typically, and where the interruption actually does prevent the tenant from using significant part of the premises, and the tenant does not use significant part of the premises. So it's not just a theory, it actually does have the actual impact. Another area, casualty. We're now making it clear that casualty means physical damage and not something that, you know, someone's tried to say, well, pandemic, that's kind of like casualty. Similarly, condemnation or taking. We're excluding governmental action that requires a tenant to cease its operations in premises or actions taken to protect public safety. I mean, that could be anywhere from boarding up because of concern about riots. We're trying to exclude that and actually limit condemnation to taking to a more traditional concept of what that is. We are expressly including landlord default provisions. Why would you do that? Well, because you want to make it clear what the remedies are and what the cure rights for a landlord are, and not have a court either impose a much shorter cure right than you might have, and also making it expressly stated that the remedy of a tenant for a landlord default will be limited to damages, equitable relief, it could be injunction, but not lease termination. We'll be talking about operating expenses, and I don't want to go over, so I can either discuss that a little bit now, or maybe we can wait till the next segment. I'll leave that to you. But
yeah, let's do that.
Use provision, you know, tenants are required to comply with the use provision and their use of the premises. We also want them to comply with applicable laws. If they are required to cease operation, they also have to comply with that as well. Kind of a general tip, if a landlord makes a concession, and there's concessions I've typically seen, at least in the office context, and sometimes retail you'll see a bit more, has been rent deferral, not rent abatement. So ultimately the tenant has to pay the deferred rent, but it'll be over a longer period of time. And my one suggestion is, if the landlord is going to make that kind of concession to the tenant, think about what it is. Is there a concession the tenant can make to the landlord? In a retail context, one that comes up is seeing about having the tenant waive a co-tenancy provision, which could otherwise either allow a tenant to not pay rent at all or to get out of the lease or something. So if the landlord's going to give something, again, figure out what in return, and that's going to be fairly specific to particular deals. And just finally, I've been talking more about leasing, but in purchase and sale, force majeure is something to consider for due diligence period. It may impact, I was in a deal where it impacted the ability of my client to do testing. This is over the summer and the fall. And so we really had to think about how we were going to allow that due diligence period to be expanded. Same thing with closing date. If due diligence is delayed, closing date may be delayed. So anyway, those are some of my thoughts, some of the lessons learned. And again, operating expenses we'll discuss separately.
Yeah, and Sarah Ann or Ginger, are there any other lease provisions that you're recommending to make some changes to in the future to kind of, now that we've been exposed to this, you would also think might need to be changed in your leases that, you know, have been a result of the pandemic?
Well, Nancy, I agree wholeheartedly on having landlord default provisions. I've always had them for just that reason, so that people And because I always want as a landlord to get that 30-day notice and opportunity to cure and not have the tenant try to buzz out of the situation. I think that in response to what the government has done, I have a lot of clients who are seeking bigger security deposits. They're seeking bigger security deposits. They're seeking guarantors. Even on established companies now, they're seeking guarantors because it's very, very few jurisdictions. There are a couple, but very few jurisdictions that have provided any protections to guarantors as opposed to tenants. So that's a thing that's been very positive for people who had them as an alternative repayment. Also, I'm seeing a lot more people talking about letters of credit for deposits as opposed to cash deposits, because in some cases you can ask for a much larger letter of credit than people are willing to part cash with the landlord. And that's also something that is giving people an opportunity to get their funds collected. It's unfortunate that, you know, in the before time, the pre-COVID, the before time, when we had a tenant with an established business, we didn't worry as much about things like guarantors and large security deposits. But unfortunately, given the world in which we find ourselves, the only immediate solution to what the government's done that some tenants, some landlords now have, is that if they had these larger security deposits or letters of credit or guarantors. So I'm seeing a lot more interest in those kinds of provisions. Also, we've had some conversations about the licensing of an outdoor area. That's also becoming something that's of interest. Some landlords who had not licensed outdoor areas before were nevertheless making parts of their parking lot or sidewalk available for people who could operate outside but couldn't operate inside. And we are seeing more tenants who are interested in outside areas, not just food service, that want to put a few tables and chairs out there. And we are adding special provisions. I usually do it as an exhibit, but I make it very clear that the outside area is not part of the premises, so that if that outside area is taken away, it doesn't change the amount of rent owed or the square footage or the percentage on a multi-tenant calculation. It's simply something that we allow in certain circumstances, but more tenants are being interested in having that right to use outside area. And we're being very careful to make sure it's not part of the leased area, so that if the outside's not available, they can't say they're entitled to rent reduction.
Ginger, do you have something that you like to see different in the leases going forward after your pain and suffering for the last year?
I think Nancy and Sarah Ann gave a good overview. I wouldn't have anything to add to those.
Great. All right. So the next question we want to chat about, because it came up and we're all kind of facing it, I know everybody side is the operating expenses. Because without a doubt, this year was the most unusual year, where we were doing a lot of building maintenance and making sure the building was in tip-top shape, so no one can claim they didn't have to pay the rent because we weren't providing the level of service. So from the property manager side, we worked hard on that. But this is certainly not a typical year for what we've had to do to maintain our buildings either. So, and I know that if you were representing a tenant, you'd have an argument for it. And if you were representing a landlord, you guys would have another conversation about it. But I think everybody on the group had their thoughts about how the pandemic, how to approach the 2020 operating expenses and going forward. So Nancy, why don't you lead off a little bit with it? You alluded to it, and then we're going to let both Ginger and Sarah Ann give their 2 cents on it, because this is definitely going to, we're doing CamRex right now, so it's going to be definitely relevant. And also, obviously, we're still in COVID, so it'll apply to 2021 as well, and hopefully not 2022, or I'll be done.
Right. Well, you know, a few things. First, their 2020 has been unusual, both because there are extraordinary expenses, such as the level of cleaning, janitorial. So in that aspect, things have been higher, but the occupancy has been so much lower that certain variable expenses are much lower. And where this can really have an impact is if you have a 2020 base year. And so one thing you got to think about is, if that's 2020 base year and you're a tenant, does that make sense? or should the base year be grossed up to a more normal year? But then, you know, maybe the landlord says, we knew it was very low year and that's why your base rent was so low. So there isn't, you know, sort of a one answer. It's something that needs to be considered and not just, you know, I assume it's going to be fine, because it may not be fine. Another thing, if you have a lease where you've got controllable expenses that are subject to a cap, 2020 could either keep that cap artificially low or could prevent the landlord from including in the cap stuff that on the face of it might look like controllable expenses, but they're really not. These extraordinary cleaning expenses that no one really had thought about, or expenses to comply with law. You really, as a landlord, want to exclude those from a cap if you've agreed to a cap on expenses. And then just gross up, I'm going to suggest that probably a lot of our leases will talk about if the building is not fully leased. We really now are saying if it's not fully leased and occupied, because that second question, not only, you know, is it at least 95% leased, but is it actually occupied, will have such an impact on what the operating expenses are.
So Ginger, on your people with their expenses, obviously we're not collecting rent. We really don't want to give away operating expenses as well. So kind of what is going to be your approach on the, you know, because I think there's going to be pushback from tenants on, I wasn't in the building for the whole year, you know, concept, which for some of them, it is true. They haven't been in the building probably for almost a whole year, but kind of what is going to be your, you know, your approach to this with your clients, and how are you going to try to do the most you can for your clients?
Well, as the litigator in the group, I enforce the terms of the lease and I ask for every single penny that I can ask for. And so I look at the lease terms and I rely heavily on the Nancys of the world to provide me with a lease that lets me do that. In practical terms, though, it's really, what does this landlord need and desire? And we're looking at ways to negotiate outside of the lease, and not only on a per property basis, but with regards to each tenant specifically. What can that tenant do? How do I keep that tenant? How do I keep the space filled? How do I get customers to come here? So it's difficult to answer your question because I'm going to ask for every penny, but it really depends upon what the goals are of the client in the situation and how do we make it work in this pandemic we're all suffering from.
Have you seen any trends amongst your clients, like a couple paths that they normally are taking right now when faced with this?
With operating expenses particularly, most of my clients are working with tenants on base rents, but not operating expenses. There may be a deferral or an abatement as to the base rent, but most are asking, requesting, and negotiating to get 100% payment on operating expenses.
Gotcha. Sarah Ann, how about your clients?
So, you know, I'm obviously in agreement with Ginger that everybody's trying to get 100% of the additional rent, and then they're willing to negotiate deferrals on base rent, depending on the level of debt service. Because obviously landlords that have much lower debt service have a little more flexibility. Landlords with high debt service, there's just very little they can voluntarily do. In many cases, the lender's documents don't allow the landlord to make changes or even go into these kind of negotiations to defer rents without the lender's approval, especially in recent loans that have higher loan to value ratios. You have to get the lender's approval, and for the most part, they're not approving. So that's an added complication. In terms of the operating expenses, however, I think that people are having to make a very different look at their gross up provisions than they ever did before. As Nancy mentioned, a lot of the gross up provisions are looking at if the building is not leased all the way up, and it doesn't, those languages often don't address a situation where it's leased but not occupied. So in our new lease provisions that are going to need to clarify moving forward, the gross up provisions are going to have to clarify what we mean by leased versus occupied and how that applies. In the past, however, in a building where, again, we didn't worry about occupied versus leased, we just said, okay, it was 90% leased or 95% leased, and we grossed up. We grossed up everything because we presumed that all expenses would go up or down with the occupancy, and that the occupancy had this variable impact on all the different expenses. Now that we've had the circumstance of leased but not occupied, we've discovered that there are some expenses that really are variable, that really do go up and down in proportion to occupancy. And there are some expenses that don't. The cleaning and the additional cleaning we've had to do being a great example. You can have a building that is 30% occupied, 90% leased, and yet the cleaning level you've had to do and the janitorial you've had to provide is the same as when every single person was back in the space, even perhaps more so because of the added cleaning. So for those people who are looking to do gross up calculations, I am advising that they take a look at those expenses and make a determination and put them in a category. Is this an expense that actually really did go down because of a lack of occupancy and therefore is fairly grossed up? Or is it an expense where I really did pay the same and do the same if I had 90% people versus 30% people, and that expense probably should not be grossed up? Obviously, we've never had this situation before. Landlords and tenants are going to argue about these things, but I can tell you that if and when you get into the argument, it's always important to be the person wearing the white hat in the courtroom. You have to be the good guy. And to be the good guy, you have to show that what you've done is reasonable. So rather than just grossing everything up, I'm strongly advising that people sort those expenses into what's truly impacted or not impacted by occupancy, and do not gross up those things you paid the full price anyway.
I actually have a couple clients that are doing test fits right now, I call it. So they're having us do the gross up based upon a lot of what Sarah and all of you have said. But they're also making us compare it to 2019 gross up number because they don't want 2020 to be higher than 2019. So that's kind of like if something is skewed, then they reevaluate the variable portion to wonder if maybe, you know, the piece or the part that they called variable, you know, it may be. That's been our new test fit. We go back and like, well, how do we do in 2019? Like, well, this is way higher than that. And yeah, that's probably not going to work. And we're not going to feel good about sending that camera out. So I do think, I think we'll probably 6 months from now have a better feeling for what all this is going to be, which hopefully will make the 2021 a little easier. But yeah, I appreciate all your input on it because I agree. I don't think Ginger wants to go into litigation unless we've been really reasonable on the grossing up and things like that. And she'll be the one evaluating our work to make sure that we were reasonable before she advises our clients on what to do. So I appreciate that. And I am curious to see how it's all going to come out. And I think this year, when we send those first letters out, and I haven't had to send any of mine out yet, it's going to be interesting, but we'll hear things we haven't heard before. So the next portion before we kind of do another part is Sarah Ann is going to help us understand what legislation, what regulation, where the government is looking in the future and how it's going to impact our ability to resolve this. Like Ginger's waiting to get into courtroom and try to, you know, get some of these spaces back or make decisions, you know, outside because we still are kind of hung up with that. So she told us kind of what got us here, but now what's also in the horizon that could have an impact on how all this gets resolved.
Sure. So as we know, there is what the state's governor's order is what I'm going to call an authorizing order. The governor at this point in time, and there's some bills pending I'll mention briefly, but right now as we sit here, the governor is not in fact imposing an eviction moratorium or imposing anything in particular. What the governor has done is done an authorizing order. And what it basically does is it authorizes counties and cities to pass their own rules. It suspends the obligation of the county and the city to give us the rights of eviction and all the other rights in our leases, and allows the counties and cities to suspend those rights based on the terms that they put forward. Now, in many cases, the county has passed an order. In many cases, cities have passed orders. In some counties, such as Alameda, the county order only applies to property in the unincorporated area of the county. And then the cities are left to their own devices to pass their own ordinances. In places like Santa Clara County, the county ordinance applies everywhere, but cities can impose even more restrictions. So the first thing I have to tell you is there has been no preemption in Sacramento of any particular type. The housing folk got preemption. The state law is the law. We have no preemption. So if you're trying to figure out what you can do and not do in the current regulatory climate, the top advice I have to give you is you have to check your county order, you have to check your city order. Everything else I'm going to talk about is generic, but with the caveat, must check county, must check city, got to see what they say. The governor recently extended his authorizing order. It was due to expire March 31, and it has now been extended to June 30th. We know also that he's announced that he's reopening the state effective June 15, as long as we continue to have our numbers stabilize, et cetera, et cetera. Now, obviously, nobody can predict what's going to happen with any of that. However, we know that if he intends to reopen June 15 or June 30th, and that authorizing order is until June 30th now, I have to hope that that will be, in fact, finally the last time. It's been extended 4 times now, but maybe June 30th will be the end of the authorizing order. There are some jurisdictions, you have to be aware, that don't think they need the governor's authorization to pass what they passed. That's a very aggressive position for a city or county to take, but some of them have taken it. That will no doubt be tested in court absolutely the day after the governor's authorizing order expires. But right now it's out to June 30. Many counties have passed ordinances and continued again to extend them over and over. And several counties have decided to be aggressive, and they actually extend their orders longer than they're authorized to do. And they put a clause in, and Santa Clara is one of these, by the way. When the governor's order expired March 31, Santa Clara County had passed an ordinance saying it would expire April 30 or when the governor's order expired. So when the governor's order was expiring on March 31, that was the date, but they had passed it all the way to April. When the governor hopscotched and said, okay, now we'll go to June 30th, a lot of jurisdictions, and Santa Clara County is one of them, passed extension, and they extended all the way out to August 31st or until the authorization order expires. So if the governor's order expires on June 30th in Santa Clara County, for example, the eviction moratorium will expire June 30th. If he extends it to December 31 in Santa Clara County, it would now expire August 31 because that's the date in the statute, in the ordinance, because it's this either or. As long as the governor lets us, or until this date, whichever comes first. And we're all hoping, we have to hope that June 30th is the end of the authorizing order, and that will therefore be the end of the eviction moratorium. And as far as the governor's order and the county orders are involved. Now, that is the playing field we find ourselves in. As Ginger mentioned, one of the important things to note is the governor's authorizing order is affecting evictions only. The authorizing order from the governor and most, but not all, of the county and city orders state that they are not interfering with the right of a landlord to collect their rent. They're only interfering with the right of the landlord to evict a tenant for failure to pay that rent. That doesn't stop tenants in court from arguing that seeking your money is the moral equivalent of eviction, and therefore you shouldn't get to do that either. So far, I don't know of anyone who's actually lost that argument. I'm sure I'll hear about it on the news feeds if it happens. But right now, it's all about suspending the Code of Civil Procedure on eviction, not about actually taking the contract right. And the government's been very careful about that because they don't want a bunch of landlords saying, you took our right to pay rent, that's taking, you have to pay us. That's the place that people will start going. Because if you say, if the state says you don't have to pay the rent at all, now you've taken my property right. And case law says that property rights are not just land, it's also other personal property, which includes money. So that's going to be a very interesting argument. We're all hoping that the eviction moratorium will therefore end June 30th. Now we have to deal with, what do we have? We've got all this rent that's owed. What do we do? And right now we have 2 bills that are currently pending in Sacramento. If you want to look them up, they are AB 255 by Muratsuchi, and it is AB 1146, which is Cervantes. AB 255, Muratsuchi's amendment, is similar to last year's SB 939. What Muratsuchi wants to do is he wants to define the qualifying period as running all the way out through August. In fact, he's running it all the way to August 1. So now we're going even a month past what the governor has done. And he wants to say that a small business tenant, which he defines as $5 million of gross receipts or less and 50 or less employees. And all of you who manage property know that 5 million in gross receipts and 50 employees is not a small business. Okay, that is not a definition of a small business. That's half the businesses in California. That's between 50 and 70% of the businesses in California fall into this definition. He wants them to have an additional year to pay. And in similar fashion to what happened on the housing side, he says that the tenant and the landlord can negotiate, but if they don't agree, and of course, there's no criteria for what the tenant has to agree to. So the tenant can just say waive it all or else. So there's no agreement. The tenant only has to pay 25% of the total amount of rent due from March 1 all the way to August 1. And if they pay 25% of that rent, they get a year to pay the other 75%. And that's, by the way, not a year where we pay each month. That's the whole thing a year later, another year, no late fees, no interest, etc. He has tried to make one teeny tiny carve out that if the landlord can show that the failure to collect the additional 75% of the rent will put them in default of their financial obligations, then they can evict the tenant. But it's the landlord's burden to prove that. And of course, if you file the complaint and you lose the complaint because you don't prove that to the satisfaction of the court, you're going to be paying the tenant's legal fees. So it's a very, very frightening situation. The California Business Properties Association and all the different groups that belong to that, which includes CRE, BOMA, NAIOP, IREM, and all the other organizations, we're opposing AB 255. It's, in my view, unconstitutional. I've written the legal analysis, and the Assembly Judiciary Committee analyst is currently going through that process. There'll be a hearing on it at the end of this month. And then we're hoping that we'll be able to stop it, maybe not at that hearing, but at the Appropriations Committee. At some point, we may be asking you to participate in a letter writing campaign to defeat it, but so far we are still working on it through the legislative process. So that's a bad bill for us. If it passes, you're going to be looking at another year to wait on the rent. So let's light a candle, say a prayer, and if we get to that point, write a letter. The other bill, AB 1146 from Cervantes, is actually trying to help us, but unfortunately lacks the funding to do so. It is an attempt, and I applaud the attempt, to pass something similar to the Relief Act, the Rental Assistance Act that was passed for housing, where the idea is that counties would have the opportunity to let landlords have a reduction of property tax credit in exchange for forgiving a certain amount of rent for the tenant. The problems that it's running into are, number one, on the housing side, the deal was if the landlord waived 20% of the rent, the state would give them 80% of the rent, and then the state would collect that money through its property tax mechanisms and other mechanisms from the tenant for us. So they were going to pay us and get paid back. The tenants would pay the state instead of us. We took a 20% haircut. I have a lot of clients who'd take that haircut in a heartbeat if it meant they got the other 80% of the cash in their hot little hand right now. Unfortunately, there's no money like that dedicated on the commercial side. Nobody wants to put up that kind of money. So the Cervantes bill, the theory here is we would give up our right to our future rent, but we're only going to get like 30% of the rent paid. And I know of almost no one who can afford to take the 70% haircut. Also, it would be limited to the amount that you could get on property tax credit. So again, we have a lot of landlords where property tax credits are of no value to us, not only because we may or may not have higher taxes, but because they're pass-throughs. And so if we take a loss on the rent in exchange for a property tax credit, and those property taxes are passing through, we just gave up our money and the tenant got the return money. So it doesn't help us on anything that's a modified gross or triple net lease, because we're giving up our rent and the tenant's going to get the benefit. So unfortunately, that bill's not written in a way that will help us. It will actually just be an attempt that won't do anything. The big concern though, is that if people think, oh, you have this solution, they're going to feel okay on imposing other restrictions on us, like the AB 255 that says we don't get our money. We're going to continue to have these fights into the summer. My concern is that the governor, even though he opens the state on June 30th, he might still extend the moratorium because he, again, will want the legislature to have a chance to fix it. And so it is possible he'll extend it again to August 31, which is the end of the legislative year. We're hoping to get these bills resolved before then and give him no incentive at all to extend past June 30th. But as I said at the beginning on my, oh dang, I was astonished how long it lasted before. So in the hoping for the best and planning for the worst, I would hope that June 30th is in fact the end of the moratoriums. I would plan expecting that the governor could again extend to August 31 to give the legislature every last chance to do something to help the tenants, the little guys, before the whole thing comes apart.
Thank you, Sarah Ann. And obviously there's a lot pending there, and we'll all be watching it closely, and hopefully the organizations we belong to can help us know where we can go in to do it. So we have about 5 minutes left before the Q&A. And I wanted to kind of give each one of you an opportunity. We'll start with you, Ginger. Like, what's been pivotal? Where do you see your energies and efforts being spent, as we're hopefully in the COVID, I'm going to be optimistic here. But, kind of where do you see your energies, and how is this going to pivot for you going forward?
There's going to be a lot more negotiation happening before the lease or during the lease negotiation period with regards to how to address this in the future. There's going to be a lot more pushback from the tenant asking for relief now with this happening again in the future. But I don't know that the landlords are going to be very open to discussing that, because why? I can get another tenant in. So, I mean, I don't know what's going to happen. It seems like a lot of people have downsized or will be downsizing in their square footage. So possibly there's more available. How does that affect the negotiation? But certainly there will be a lot more of what do we do if this happens again, and can I get protection now?
Gotcha. Nancy, how do you see the future of what you're going to be doing, and how is it pivoting already?
Yeah. Well, first, and I'm going to suggest something optimistic as well, Jill, so we're on this same front. Disruptions can create opportunities. And I think the opportunities that I've definitely seen over the last year in my practice has been industrial leasing. I mean, it's going great. They don't need any rent concessions or anything else. And so I think kind of keep your ear to the ground and kind of be on notice for where things can, where there can be opportunities. And I think with, say, in the office context, I know that smart landlords are looking at how can we differentiate our buildings? What could we do? Touchless this, touchless that, more space, here or there to make their buildings more attractive to tenants. So that's where I'm sort of seeing in a positive light what I expect to see over the next year or two.
Great. And Sarah Ann, where do you think the pivot will be?
I think a major pivot, besides all the things we've already talked about, I think a major pivot we haven't touched on is going to be tenant mix. I think that we've always been concerned about that in a retail sector. We don't want 3 jewelry stores next to each other, but I think that tenant mix is now also going to drive a certain amount of leasing in any multi-tenant situation, even office, because we've discovered that there are those businesses that are more able to pivot to working from home. And for the most part, those tenants in the office environment that have been able to work from home, they may be grumbling about their rents, but they're paying them. Businesses that are less able to pivot to working from home have had to struggle, and landlords obviously have to work with them more closely, because at the end of the day, no landlord is benefited by losing a tenant with a big AR. That's just a sunk cost in terms of getting a new tenant in. So I think that tenant mix in terms of what the business is and what they do We had a little bit of that after the .bomb bust in 2008. Landlords who did not give their entire building over to .commers found that, I had one landlord, a client who would refuse to rent more than 30% in any building to .com people. They did okay when the .coms went out of business. The ones whose whole buildings were those did not. So I think, and then we kind of got away from that as a mindset of thinking we need tenant mix in a non-retail environment. I think that's going to come back. I think that when we look at how we lease buildings, I think we're going to be looking even in office environments and multi-tenant environments that are not retail. Who are they? What do they do? How resilient is their business? Am I going to have tenants who will still be able to pay my rent if and when the big time comes? And I think it's going to change the interest in who we lease to on some of those buildings.
Great, thank you. I appreciate all your comments, and there's a lot more we could go more depth, and as we discussed on our call, you can get really granular on all the issues, but we were trying to give people a little more overview of kind of where we're at today and where this, commercial real estate, the leasing and negotiations and vacancies and all the things we're dealing with. It's still dealing with and going to probably be dealing with through the hangover of 2021. So we are at the point where we now are going to take some questions from the audience, and Michelle or Nate, you were going to share with us, because I told you I was terrible at jumping in the chat room and figuring it all out myself. So is there any questions right now for the group that we want to put out there?
Yes. So Ginger, you kind of touched on this, and I had the question, is there any language that can be added to the LOI to address the potential uncertainty of being able to stay open for business if the area is affected by a government shutdown to protect landlord and tenant? And I know you said they'll just go to the next tenant who wants the space, but is there something for that we can put in the LOI?
If I'm a tenant representative, I'm absolutely going to be putting in the LOI that there's going to be some reduction of rents should this pandemic sort of occurrence happen again in the future. I'm going to ask for some discount in rent. I'm going to ask for space outside. I'm going to ask for leeway in paying deferred payments. Don't know if you're going to get it, but absolutely would put it in. A sophisticated tenant is going to put that in.
Let's see, what will be the sophisticated landlord's response?
No. The sophisticated landlord's response is going to be no.
Let me just throw out one sort of drafting tip that you kind of, Ginger, your suggestion kind of touched on, is this ability to kind of say in a retail setting, you want to be able to put out the chairs and kind of expand the premises, whether or not you, pay for it for rent or not. And that is to make sure that the retail lease, the landlord's retail lease, gives the landlord the ability to convert common area space to exclusive use space without getting the approval of the other tenants, because that actually has become something that's kept centers healthier if they're able to do that, but they may not have a right under certain leases. So anyway, just a suggestion.
Great suggestion. All right,
Okay.
Michelle, another question?
So Dee just put a question in the chat, and Dee, I'm actually going to ask you to come off mute because I'm not clear on the question.
Okay, sorry. So this is a real situation. I represent a landlord that's got a gorgeous industrial building right on Highway 101 in Santa Clara. He's had a gym tenant for quite some time. As we all know, the gyms have not been open. This guy has absolutely no money. And so landlord is thinking he's better off letting the guy go, getting a paying tenant in there, because industrial is actually doing quite well right now. Are there any, my question is, and without going after any money from this guy because he doesn't have any money. So my question is, are there any gotchas or concerns we should have in drafting that agreement between the tenant and the landlord?
I mean, I
Yes.
guess I have a couple because I do run into that situation. Number one, is there a loan against the building? Do you need to get lender consent? So make sure that you don't terminate a lease and put the landlord in default under its loan because you failed to get consent from the lender. And then secondly, here's one of these places where the lender's being really nice and, you know, letting the tenant off out of its lease early. Make sure there's a good waiver and release of claims, so the tenant doesn't come back and decide, maybe I should, you know, recoup some rent that I did pay, or who knows what claims they'd want. You want them, make sure you've got the concession from the tenant that they've given up any rights against the landlord.
Okay, so a release claim, no rights. Okay, and thank you.
And how about the equipment? Is the equipment of any value? Is that something you want or you don't want, you know, as a landlord?
Okay.
There's one other nuance in that, and you have to be careful of this as a pitfall. As Nancy said, you want to get a release or at least an estoppel. Sometimes I do an estoppel instead, because as a landlord, you do not want to give a release in return. That's very, very problematic. When I do those kinds of deals, instead of doing it as a settlement or something like that, I generally do it as a termination amendment, where I simply change the natural expiration date of the lease to be the date he's going to or she's going to give me back the space. And the reason it becomes important is if you give a mutual release, you need to carve out exceptions and exclusions that would otherwise survive the lease term. The key one of that we run into all the time is, remember, the tenant's insurance doesn't have to pay if the tenant isn't liable. And you don't know if somebody tripped and fell in the gym 6 months ago. And now they're going to sue 6 months from now. They're going to sue you and the gym owner. And now you can't get the insurance because you did a full waiver. So either just change the termination date to the date they're giving it back, and then it's a natural expiration. Do an estoppel or a one-way waiver, although a lot of tenants don't like those. Do an estoppel. We don't know of any claims. But if you're going to do a release that's a mutual release, make sure you carve out things that would otherwise survive the termination of the lease, because you got to keep the insurance companies on the hook for anything that third-party claims that may come up you didn't even know about now that you're terminating. So be very, very cautious with that.
Okay.
One more question, Michelle.
I actually had a question. Sarah Ann, you probably would know this. Is there any policy in the works that will give relief to landlords related to their credit for tenants who haven't paid rent, that they were unable to meet their debt requirements? I mean, like their credit scores.
Yeah, there's nothing currently pending in the state of California to provide relief to commercial landlords who are in danger of default. The federal programs concentrated on Freddie Mac and Fannie Mae loans, which are going to be primarily residential. There are a few regulations that may work out for SBA loan borrowers. If you are in fact a landlord with an SBA loan, there's a couple of things going on. But most landlords are not eligible for PPP loans. They are not eligible for most of the SBA programs. Very, very few small business landlords might fit into one of the SBA models, but for the most part, if the landlord and the lender can't work it out, there's nothing I have heard on the horizon to protect landlords from having their properties foreclosed on, for failure to meet their rent obligations, or for their failure to meet their capital and LTV obligations. Because remember, you can be paying all your payments, and in many loan documents, if the collateral is seriously impaired, they have the right to either call enough principal in to lower the LTV to an acceptable level or put the loan in default. Be careful of that also if you're going to file for a Prop 8 tax reduction. Remember, if you file for Prop 8 tax reduction, you are saying your property value has been lowered or impaired. You don't necessarily want to do that if it's going to be used to cause an issue with your lender. So unfortunately, the state is not currently looking at helping us from that perspective, and do be cautious about putting out into the world statements that your property value is impaired. You want the Prop 8 tax reduction maybe, but it could have other consequences. All I can tell you as the number one advice is read your loan document. If you don't understand it, have your lawyer read your loan document and give you advice before you do something that could impair your collateral or could cause you to be in default under that loan. But I'm sorry, I don't have better news for that. Everyone who knows me knows that I'm a straight shooter that way. I'm not going to give false hope.
Well, we are at the end of our hour. It went quickly. First, I just want to thank Ginger, Nancy, and Sarah Ann for sharing their expertise. I know that there's so much more that they probably could share, but we have to fit it all in an hour. So we want to be mindful of everybody's time. So thank you so much for taking your time. Thank you for giving us some heads up, all of us who work in the industry. I certainly that's while we were doing this, because I've got a few clients that we'll probably need to be having some discussions with, and I will do email because I don't do my Twitter and LinkedIn yet for our breakout room, but I'll get there. Anyway, thanks to everyone. Thank you for everyone who joined. We appreciate you being here. Please go out and have a great day. Be safe. I'll be vaccinated by the time we meet again. Thank you.
Thanks for asking us.
Thanks, everybody. Thank you.
Jill, yay.
Great job,
thank you.
ladies.
Yay.
Thank you, ladies.
Thank you.
Thank you. ladies.
Jill, wonderful job thank you for being our moderator. You're fabulous.
My pleasure.
We may come back to you. Awesome.
That's the punishment for doing a good job, is more of the job.
That's hilarious.
Bye.
Isn't that how it works?
That's right. Well, Dale, I hope you're enjoying yourself. Look at that little one. Look at that cutie you have there. Who is that?
Her. Isn't she adorable?
She is so cute. Yes.
Yeah, I like your teddy bear.
Oh, I know that he's been with me a long time.
I can tell. He looks well loved.
Your moral support.
We're glad to hear that, Nathan. We're glad it's not a
Guys,
recent
that
purchase.
camp was
Okay.
fabulous. Really a great job. It was really informative.
Sarah Ann, I don't think I've understood those concepts, and I kind of work in government, and now I do. So thank you very much.
Oh, about it being an authorizing order, not an actual order.
Yeah, I could never figure out what the county was doing and sort of why they had to wait for the governor, but then the city does stuff too. And so anyway, it makes a little more sense now.
Great. Well, thanks for inviting us. I think it was a great program.
Yeah, you guys really worked well together. It was a good kind of dynamic. So good job.
So,
Nancy, have a
Michelle-
good afternoon.
Thank you for getting me in.
Hi, Nancy.
Hi, Dale. How are you?
I'm good. How are you? You
I'll
look
have to stop
fabulous.
and see you
Take
on the way
care.
to Tahoe.
You
I
better.
look forward to our first in-person program.
June, we're
Yes,
going to plan for
Sarah.
June. All right.
Fingers
Okay,
up.
bye, everybody. Good
Bye-bye.
job.
Bye.
Bye. Take care.